Thank you, folks. Have a seat. Yeah, I see numbers flashing, so I'm going to wait until I know we're set to go. It all looks very exciting. So we have 1959 and 2001. Is that okay? All right. Thank you, folks. This is the time set for oral argument 1CA CV22 0634, Chelsea McCombs et al. Versus the Joyce C. Miller Living Trust et al. We have read the briefs and have conferenced the case earlier. We are going to be doing oral argument from the podium, as was tradition and is returning. Masks are not an issue from what I see, so you folks are free to do that. We are recording and broadcasting these proceedings. Please be sure that when you approach the podium, you identify yourself by name and your client. Each side does have 20 minutes. The clock does count down. I know you folks know that, but we review this for everybody. Counsel, if you wish to reserve any time for rebuttal, that is your responsibility. We do not reduce it from or take it off of the time. You'll just need to make sure there's time left. Each side does have 20 minutes. You don't need to use all the time, but please feel free to use the time. We do ask that you focus your arguments. No need to repeat the briefs. Again, we have read them. So with that, counsel, if you're ready.
Good morning, Your Honors. My name is Amy Sells. I'm with Tiffany and Bosco. I'm here on behalf of the appellants Chase and Chelsea McCombs. This is a fascinating case in that it is a battleground for testing recently amended rules or somewhat recently amended rules. On one hand, starting with Rule 37 that was amended back in 2018 in order to make mandatory disclosures under Rule 2016 Rule 26.1 more robust, and then on the other hand, the elimination of peremptory strikes. I'd like to start, well, first I should say I'd like to reserve 2 minutes for rebuttal. And I'd like to start with the issue of the 483 undisclosed photos because I think that's our premier issue here, and I'd like to discuss intervening superseding cause because I think that's where the rubber hits the road. Remember at trial, the precise origin of the fire was not determined. The best that the experts could say was that they agreed that the fire started in the northeast quadrant of the living room. In that northeast quadrant was Debbie's smoking chair as well as the entertaining center. And that meant that the cause of the fire was most probably either an electrical fire or a cigarette fire. And so the defense said that Debbie caused her own death by starting the fire with a cigarette. And when you look at the closing argument slide that defense counsel used, he used a slide that set forth nearly all of his intervening superseding cause theories. And it was a slide that was titled, Debbie Died Because. And it's 5 bullet points, and the first bullet point is, she accidentally set the house on fire with a cigarette. Second, she decided to fight the fire. Third, she fell into a burning chair. Fourth, she didn't escape when she could. Fifth, she was in poor health. Now, defense on appeal says that we should ignore 4 out of 5 of these intervening causes and instead just focus on one, that Debbie stayed to fight the fire. But if you look at the jury instructions, the definition of intervening superseding cause does not restrict that theory to Debbie staying to fight the fire. And in fact, the definition actually isn't tethered whatsoever to any of the intervening superseding cause theories.
Counsel, are you arguing that the specific mechanism of the fire's origin is is really the crux of the causation issue? That there's a substantive difference in the decision to fight the cause about whether she caused it or an electrical, or there was a spark out of the entertainment system. Is that what you're arguing?
Yes, in part. That I would phrase it another way in that the precise origin of the fire and the precise piece of furniture that she fell on is relevant to intervening superseding cause.
Please go straight to that. Let me hear what you say about that.
Okay. Well, if they're arguing, for example, no, the origin of the fire is not an electrical fire, but in fact Debbie started the fire with a cigarette, then that in and of itself is an intervening superseding cause of Debbie's death. On the other hand, with respect to, and so that breaks the causal chain, right? On the other hand, with respect to the precise piece of furniture, their argument is that she stayed to fight the fire which was located at her beloved smoking chair. With the benefit of these 483 photos, we are now able to make the argument that the burns that are on Debbie's chest, which reflect a 2-inch and a 1-inch serpentine burn, are consistent with the coils that are on the couch on the south side of the living room, as well as that chair that's on the west side of the living room, both of which have coils that are mixed 2-inch and 1-inch. So in other words, we're able to argue that she didn't stay to fight the fire and then fall into her smoking chair. In fact, it appears as though she was doing exactly what defendants were saying that she should have done all along, which is trying to escape, and in the process fell into either the couch or the west side chair, which are on the way to either the carport door or the sliding glass door.
But not the front door with the double deadbolt lock.
That's correct. Well, it is their theory of intervening superseding cause that she stayed to fight the fire, and that's why these particular pieces of furniture and the origin of the fire become relevant, is because it relates to their defense. Am I not?
Correct, but the theory of the case was the double deadbolt lock, the failure to, or actually the violation of putting a double deadbolt lock on an egress, delayed exit and then resulted in smoke inhalation and death. Was that not the theory?
Right, that is the theory, and then their defense is, well, she should have sought out alternative routes, number one, and those alternative routes being the carport door or the sliding glass door. And in the process, instead of seeking out those routes, she decided to stay and fight the fire in the living room.
But your theory, as I understood it, your client's theory, was the smoke alarms weren't activated, they were taken down, the front door was dead bolted, and it doesn't, whether she, you can say she stayed to fight the fire, it wasn't that, she was overcome and never had a chance to get to these alternative routes. Isn't that an accurate statement of your client's theory?
Correct.
So your client got the instructions, did it not, that resulted in a fine that would have, as Judge Gates, I think, said, the jury had to find your client was, or the trust was negligent because these two things did not comply with statute. The statute applied, they were supposed to be functioning smoke alarms, there was not supposed to be a deadbolt, so negligence was established. Correct?
Are we talking about negligence per se?
Correct.
Yes. Well, that's a whole
so
other ball of wax.
So we got a breach. And so the next issue then gets to causation. And your argument is that the cause was those two things. Their argument is, no, there was a superseding cause, right?
Correct.
So how do these photos change your argument? I don't see that they do. I don't see how we send it back for a new jury under that.
The photos don't necessarily change our argument. They change the underpinning of the defense's arguments for intervening superseding cause, which the court in its minute entry when denying our motion for a new trial said was critical. In fact, she said that was the basis for the jury's decision, was that they focused on intervening superseding cause, and therefore, according to the court was focusing on excluding the origin of the fire as well as the piece of furniture as the basis for denying our motion for new trial.
And the only place that you could have, your expert could have found these, the information on these other two pieces of furniture, the chair and the sofa, was in these undisclosed photos. It wasn't anywhere, anyplace else.
That's absolutely correct.
I guess procedurally, counsel, new trial being obviously a very, very strong medicine for a problem that comes up, and this is, a concerning problem, the 483 photos. I thought I heard you say to Judge Faruya a few questions ago, with these 483 pictures, we can now argue, you were just explaining, Judge Goss, what you could now argue, but I'm looking at your opening brief, and there's Judge Gates finding plaintiffs did not request additional time to review the photographs or seek leave to have their expert examine the photographs to determine whether the images altered or changed the expert's opinion. Mm-hmm. Doesn't that kind of draw some of the sting and kind of cut against your Rule 59 argument? Can you speak to that and respond to that criticism?
Yeah. So in other words, the court is saying, I just want to frame this for my own purposes. So the court had said that what we could have done in order to cure defendants' misconduct is that we could have asked for more time for our expert to review these photos and determine whether or not that would cause him to revise his opinion. In order for us to do that, that would prejudice, actually, in order for us to do that, that would require us to seek a continuance of the trial. And by doing so, that would prejudice us in several ways. Number one, I think there's no better way to miff a jury than to let them know that you're seeking a continuance of the trial. And second of all, if we would have asked for more time, we now know that our expert would have changed his opinion. He has already changed his opinion, and that would play into defense counsel's existing argument that our case theory was evolving and that our expert's theory was evolving, and we didn't want to give him that opportunity to do that again. That certainly would have prejudiced us as well.
And
also,
counsel, I appreciate your argument on the same page of the brief, kind of to that effect, and I guess, and you never got there, and I understand that, and your side was in a hard position in trial because of these photos, but you also could have argued that the delay was their fault. You could have suggested, that the problem was caused by them, and the expert got these in the middle of trial because of that production. I think, wouldn't that have mitigated some of the harm that you're talking about? It
could have possibly, and then there's also the consideration that by the time we reached deliberations, we had lost 2 of our jurors and we were down to 8. And so there's a possibility with a continuance that we would have risked busting quorum, for lack of a better word. So,
which would require a new trial, which is what you're seeking.
That is true.
And isn't that part of the challenge? I mean, it's always difficult in trial, and you have to make a decision, or any attorney does. Do we ask for more time? Do we move ahead? How do we handle this? Once you make a decision and don't ask for that delay, hasn't the attorney now kind of opted for the relief and really conceded that that was not something that was necessary, that the delay, a new trial at that point was not necessary, because they could have asked for that at that moment and made a decision not to?
I understand, and I understand what you're saying, and I do agree with the preface, is that we don't know how these things are going to turn out, what the consequences of our strategic decisions are going to be. But I think in that moment, it was viewed as far too prejudicial to seek a continuance. In terms of
Counsel, could you speak to the sort of what I'll call the victim blaming argument, where you guys are saying there was no follow-up after this deposition for 7 months, and they say, well, but you didn't follow up with us more. Can you please address that, counsel?
Yeah, it's funny because one of their themes at trial was personal responsibility, and I think that's exactly the opposite of what they're doing here. They're trying to blame everyone but themselves for their misconduct in non-disclosure. And so first they start with blaming their expert. The expert didn't provide these photos. Then they blame the attorney at their firm and say, well, that attorney was actually not trial counsel and they should have followed up. Then they blame plaintiff's counsel and say, we should have followed up with their defense expert, and we don't have an obligation to ask once. In fact, under we don't have an obligation to ask twice. We certainly don't have an obligation to ask once under Rule 26.1. And then they blame Chase for springing this undisclosed testimony at trial, and they say, well, none of this would have happened had Chase not testified as such. But had they timely produced these photos, then Chase wouldn't testify in that way.
So doesn't that really go to, there was a breach? They should have disclosed. I don't think there's any way to get around that. The reality is that should have been produced. It's the remedy that we're focusing on. Mm-hmm. And what is the appropriate remedy, understanding it. And I understand what you're saying. It isn't, it's on the disclosure who has the obligation to do it, and it should have happened.
Yeah.
So why is this most extreme, really, of remedies appropriate under the difficult facts of this case? And I don't disagree. The attorney had a difficult choice to make standing there that day.
Well, I mean, what strikes me most, if we're talking about the difference between reversing and remanding for a new trial and reversing and remanding for a determination of appropriate sanctions, that might be two different types of relief. But I think that what struck me most was that the nature of this nondisclosure really went to the heart of their intervening superseding cause theories, such that if we were to have a new trial, it would be a different trial, because no longer would the focus be on Debbie, this depraved chain smoker who started the fire with a cigarette. Then it's going to be about, this is an electrical fire that was outside of Debbie's control. It doesn't matter that she's a chain smoker and that she's in bad health and all of that. Well, the jury's been on both sides, I suspect, and they're going to have to decide at best. Sure, but the storyline of the case completely shifts with the benefit.
The chair fell into her favorite smoking chair because the other piece of furniture just happened to have the same marks, and you can try and have the jury sort that out. Isn't that correct?
I'm sorry.
She could have fallen into her smoking chair or any either of the two pieces of furniture. Those are the two things that I understand these photos reveal: potential electrical fire, other pieces of furniture she might have fallen into.
Correct. That is
correct.
So
but it doesn't resolve it. It just it adds a dimension to the story. I don't disagree.
It adds a dimension to the story that is far more favorable to plaintiffs than the initial case, and we should get a crack at that, I think. But then also, I guess there is also the question of whether, in Appellee's answering brief, they say, well, the sanction that the court selected was adequate, and I think that they're really focusing on the sanction as related to Chase's testimony, right? So obviously they're entitled to impeach Chase on cross-examination, but what they're not entitled to do is to impeach him by using an undisclosed photo. And here, that undisclosed photo was up there, published for the jury for anywhere between 1 to 2 minutes. And so what the court decided to sanction by way of a curative instruction is to say, disregard the photo, disregard the testimony that comes along with the photo. But how, practically speaking, how effective is that? By that time, the damage has already been done. And also, in this particular case, we know that we've got at least one person on that jury who believes that this is an opportunistic lawsuit that was filed by Chase and Chelsea in order to get at insurance proceeds. So
did they say might be or was in the voir dire? Did they express certainty it was opportunistic, or were they saying it might be?
The way that I read it, he said that he believed that this. He might have said, I believe that this might be a case. But I think that when you read all of his statements in context, it pretty strongly indicated that he believed that this is a particular case where the folks were going after money. And so whereas credibility is...
Just to be clear, that particular juror didn't make the panel. Isn't that correct?
The opportunistic lawsuit juror did.
The juror who said that was dismissed, wasn't it?
There are two jurors that made very similar statements. One said that this case is a money grab. The other said that this case is an opportunistic lawsuit. We asked to strike both of them, and the court struck money grab but did not strike opportunistic lawsuit. Yet later on in the case, the court and even defense counsel had interposed the two, mistaking one for the other, which we think drives home the point that if you're going to strike money grab, you're gonna need to strike opportunistic lawsuit on that same basis.
Counsel, is it inappropriate in closing argument for your opponent to say the motives of of this lawsuit are impure? I mean, is that it? Are they not permitted to do that?
I think that, I believe that they are permitted to do that, and the court certainly made clear that she believed that that was fair game, but there's a difference here between defense counsel saying, just generally speaking, not attributing it to a particular juror and not attributing it to something that that juror said privately. I think in this case, defense counsel knew, number one, that we've got this juror on the panel that clearly believes that this is an opportunistic lawsuit. So it's more of a call, it's less of a, I'm trying to persuade you, hey, this is a monetary, these folks filed this suit for monetary reasons. And on the other hand, saying, remember back at the beginning of this case, when you didn't know much about this case, one of you said that it was a money grab. Well, you're right, it is a money grab, and none of us should be here. That is far more prejudicial. The one thing that I did want to hit on is that the sanction was not adequate because that sanction focused on that one undisclosed photo relative to Chase's testimony. What about the 483 photos? There was no sanction for that.
Well, counsel, because you kind of didn't want to invade your rebuttal time, but I have a two-part question exactly on that I was waiting to ask, which is, so there's 37C and 37D. Under 37C, like you guys say correctly, there's it's different when you're using evidence that you sandbag somebody with, and here it's the opposite. Like, you're right. In 37C, a requirement was added in 2018 that you have to show, the court has to aver that there was no injury from the use of the nondisclosed thing. Should the inverse logic apply under Rule 37D, which is the rule you're working under, right? And then did the court make the right finding here for them to win? In other words, that you were not damaged in any way. So both parts of that question, please.
I need the question one more
Sorry.
time.
So Rule 37D, the rule that you proceeded under there and in this court,
Yes.
says the court can basically do anything that it wants for, like, withholding stuff, which is the opposite of the 37C. Like, if you sneak up at trial with brand new stuff and use it, they're doing the opposite. They, like, snuck up at trial without giving you the stuff.
Right.
So you're in 37D, which is Judge Gates can do anything she wants in the world to punish. Should Judge Gates have to make the same finding under 37D, logically, that, like, that they're only okay if she finds it was absolutely harmless, okay, which is what you would do if they were using a sandbag document
Right.
instead of hiding 500 documents as a sandbag, right? Should she have to find it was totally harmless, and did she do it?
Yeah, I think she may have effectively found that it was a harm. She did not expressly, but she may have impliedly found that it was harmless. However, I think we have to read the rules as they're written, and if that requirement isn't under D and it's only under C, then that requirement would not apply here.
Okay.
And I am out of time.
All right. Thank you, counsel. And I'll be gracious again. I'll add a minute to give you a minute of rebuttal, and counsel will give you 21 minutes.
Thank you, Your Honor.
That's okay. Good morning, Your Honors. Eileen Gilbride for the defendant, Heather Ackerman, who's the trustee of the Joyce Miller Trust. We have several issues here that were a little bit conjoined. So I'm going to give the court the opportunity to start the argument and ask the questions that you're interested in hearing. If there's issues that you have or questions that you have, I'm going to go that way.
Sure. At the end of the relevant minute entry upon which all this hinges, Judge Gates basically, explains that the 483 photos, kind of couldn't be relevant. Since we can't know in the black box exactly how the jury reasoned, how can we know it was harmless?
Well, we know it's harmless because plaintiffs have argued that the reason it was harmful is because their expert would have changed his opinion on the source of the fire. That's what plaintiffs have argued the harm was to these photos. And that's what we have to go with. We can only go with what they've argued in their opening brief. And the source of the fire, as Judge Goss has noted, isn't material here because there was plenty of evidence of no causation, the intervening superseding cause. We don't, I don't want to be flippant, but we don't really care if the fire started in the smoking chair or if it started as an electrical fire.
Why did the slide at the end say Debbie caused the fire? If it doesn't matter, why?
Because it was part of our theory that she caused the fire and there was an intervening superseding cause that she didn't run out when she could have. I mean, that can be
Go ahead.
that can be part of the theme, is that, yes, she caused the fire. But even if she didn't cause the fire, the intervening superseding cause applies.
And aren't there two things they're arguing? I thought there were two. It was the cause of the fire and also the cause of the burns, that it showed she
Yes,
might have been.
yes,
So there's really two
correct.
things that they're arguing.
Correct, neither of which, and my argument applies to both of those.
Isn't it substantial or is it significant, perhaps dispositive, that they didn't ask at the time of the trial for the sanction they seek now? I mean, at what point is it on the person seeking the sanction to speak up? As opposed to the court granting a new trial, I guess, sua sponte, is almost what they're saying.
Well, which sanction, are we talking about the photos?
Right.
I mean,
Sorry.
they did ask for a mistrial.
Okay.
I believe. And the court said, no, we don't need to. And honestly, having read all the transcripts and having read many, many transcripts over the last 40 years, I thought Judge Gates did a phenomenal job of actually analyzing this problem. Over 3 days, she heard arguments, she heard testimony from the expert Paffrath outside the hearing of the jury. She thought about it, and she did a multi-level remedy that is certainly not an abuse of discretion. She was very considerate about it. She was very fair about it. She allowed she did an immediate curative instruction. She told the jury not to consider the photo, not to consider the testimony, and then she allowed plaintiffs to cross-examine the expert and impeach him with his failure to disclose, and said that we couldn't use the photo in the future, which was appropriate. And I don't think that's an abuse of discretion. Does the court have any other issues that it would like to discuss?
Why don't we'll hit on the jury issue, which was also brought up.
The juror
The juror
26?
issue.
Yes.
One juror was dismissed, one was not.
Yes, correct.
And in the world of where we had peremptories, that juror might not have ended up sitting on the jury, but the person did. Why was, what do we do post peremptories? Was that error, and how do we treat that?
Yeah, that was not error at all. And Judge Gates explained that the juror who was dismissed said, and quoting, frankly, I'm pretty biased right now. And that's why that juror was dismissed. The second juror, with the opportunistic statement, was not dismissed because she said that there was a material difference between that juror and number 16 who was dismissed. And the opportunistic juror said, this is just how I feel, based on what I've seen on TV and human nature. And the juror said, I don't feel that should dictate the outcome of this case. I just feel that people are opportunistic. And as Judge Gates said, that is not a circumstance that requires kicking a juror off the panel. So that was not error.
The record doesn't make this clear aside from kind of finger pointing both ways, but what's your trial counsel's reasoning for not following up and supplying the 483 photos? Part one, I'll have a second part to this, but that's concerning.
Yeah, that was an error. Again, it was a different counsel. It wasn't trial counsel. It was somebody else who was covering the deposition for him. And the somebody else, the other lawyer, said in the deposition twice to the deponent, we have to make sure and get those to plaintiff's counsel. Once was to plaintiff's counsel, and once we have to make sure and get those to trial counsel. Will you do that? Yes, I will. And then everybody forgot. And I mean, people are human. Lawyers are human. Mistakes happen. That was a mistake. And certainly had the covering lawyer told the trial lawyer that there were these photos out there in a file in the expert's office, something would have been done about it. No one remembered.
I guess
there was an accident.
The record isn't clear. I understand the accident explanation and different lawyers. I guess two things that are concerning about it that you may or may not be able to explain are, first, doesn't trial counsel read the depositions before trial, and so why wouldn't it have come up? It seems like just, sort of like U.S. versus Leon, inevitable discovery, like somebody should have figured this out, besides the fact that some other lawyer was in the deposition. That doesn't really to me, past kind of the straight face for responsibility explanation. And then the second piece of it is, then how did the one from the pile that nobody knew about that didn't get disclosed come into the trial bucket and get used in front of the jury? Because that sort of makes it really even harder to credit that kind of oops kind of explanation.
Yeah, and what happened was when Chase came out with this surprise testimony that the carport door had a double-keyed deadbolt, our trial counsel was knocked and didn't know what to do, and went back to our expert that evening and said, hey, I know that this isn't true. This is false testimony. Get me the photo that shows that. And the expert pulled out the photo that shows that. Trial counsel didn't know that he had pulled out the photo from a group of photos that the expert had never disclosed to trial counsel. He went back to his office and pulled out the photo.
Are you saying that there was a photo that showed the carport door that was disclosed?
There were photos that showed the carport door, but that were disclosed. But this particular photo that was used to cross-examine Chase was not disclosed, and it was a blow-up. If I'm correct, there was a blow-up of a photo that was disclosed.
So we've got two photos of the carport door. One that wasn't disclosed, which ended up getting used.
Correct.
And
the
one
blow-up.
that was disclosed, but still showed it didn't have a double-key deadbolt.
That's correct. That's my understanding. That's right. And the expert Paffrath testified in his deposition that the carport door did not have a double-keyed deadbolt lock. So that had been disclosed a year before trial. Everybody, that's why trial counsel on our side thought that the carport was just not an issue in this case. No one had ever raised it. No one had ever said there was a double-keyed deadbolt lock on it. No one was ever disclosed to say that, and no one ever did say it until Chase came out with it at trial. And then trial counsel said, oh my God, I know that's not right. Expert, find me the photo that shows that. He sends it or emails him the photo or however he got it and showed it at trial, not realizing that the expert had pulled that photo from a file that the expert had not disclosed to trial counsel, and so that was not disclosed to plaintiff's counsel.
Is that circumstance also applicable to the other photo? I mean, we have the two serpentine patterns, the 1 inch versus half inch. So were there photos that were disclosed that showed the burned out couch and the burned out other chair on the west side?
Yes. I think plaintiffs are saying the photo that showed there was a close-up photo of two different sized serpentine coils that was not disclosed, and I think that's what their expert was using to say after the fact, I think it was a different chair, it was the couch and not the smoking chair that she fell into, which really doesn't matter because what chair she fell into just doesn't have an effect on the outcome. It just doesn't matter.
But my point is that when we have this failure of disclosure, we have and I'm not trying to minimize this. I find it very concerning that there were 500 photos that were not disclosed, and I have very specific views about duties under 26.1.
Understood.
So I'm not minimizing that, but what I am trying to point out here, or what I'm trying to suss out here, is that there were a number of photos that were disclosed.
Correct.
And the depicted material that was in the undisclosed photos that was problematic also found depiction in the photos that were disclosed. Is that correct?
To a large degree. Now, there were something like 700 photos that were disclosed. There were 500 photos about in these files that our counsel didn't know about, that in the expert's file.
So first off, nearly half.
Additional.
483.
483. If I'm correct, if I recall the record correctly, our counsel was trial court ordered our counsel to list the unique ones that were not duplicative, and I think there were something like 46 photos that we listed that were unique is the word that Judge Gates used, and that those were disclosed to plaintiffs. Now, all of those photos were disclosed to plaintiffs on the Thursday. They had Friday, Saturday, Sunday, Monday before laying their expert's rebuttal testimony to look at all those photos. We had those 3 days to look through all those photos and list the ones that were unique. We looked through all of those in those 3 days, found the unique ones and listed them and gave them that list on Monday morning of the 46. But they had all of those photos that were previously undisclosed from Thursday on a thumb drive, Thursday, Friday, Saturday, Sunday, Monday, when Lane gave his rebuttal testimony.
I want to come back to something you said earlier, which is it doesn't matter. The coils in the chairs, because my understanding of your client's theory of the case was she stayed, she fought the fire at her favorite chair, she fell into her favorite chair, you can tell, because the burn marks matched the coils. Their theory is no, or at least the alternative theory, once they had these new photos, was no, she could have also, and we think what happened is she fell into one of these other chairs as she's trying to leave, not trying to stay and fight a fire. Why doesn't that matter?
Because the jury could believe there was plenty of evidence that she wouldn't have gotten that close to a burning piece of furniture to get the coils on her breast if she was just leaving, because the couch is on the north side and the carport door that they used all the time was on the west side of the house. They're just in two different places. There's just plenty of evidence that the fire was small enough that she thought she could fight it, whether it's in her chair or in the couch, doesn't matter, because the point is that she didn't leave. She stayed, she didn't leave. That's the decision, that causes the causal break, the intervening superseding cause.
Counsel, did the plaintiff make any of those arguments in closing to the jury, any of those characterizations about, the origin of the fire and any of those? Did they make that position? Did they offer that scenario to the jury?
That she was trying to leave and tripped or something? No,
Yeah.
Not that I recall.
Okay.
And I could be wrong, but I don't recall that.
Counsel, doesn't your prevailing in this appeal depend entirely on the immateriality of the photos? I mean, if they're even questionably material, shouldn't you lose for reasons relating to my last question to opposing counsel? More specifically, Rule 37C says, you can't use evidence that you improperly withheld at trial unless it's demonstrated to be harmless. That burden flipped in 2018. Before that, the court had to find that it was harmful to use. Now, someone in your position, like a spoliator, would have to show that it was harmless. So here, you have 483 photos, but it's the inverse case. If the withholding of the photos was material and harmless in the trial under 37D, wouldn't we kind of need to reverse? So, I'm not saying you're wrong about materiality, but if you were wrong, wouldn't you necessarily lose this appeal?
That's a hypothetical that wasn't raised in the opening brief, so I'm not sure that I can just off the top of my head respond to it now.
Well, I think
because
the briefs are about the materiality of the photos. You guys are arguing about that.
That's correct.
So that's
correct. But you're assuming that it's material, and I'm arguing that it's not. And so,
The point is, if she's right on the materiality, I'm sorry.
Go ahead.
Can I try it another way then? Okay, assuming that they're right, that the photos are arguably material, what's your path to winning the appeal? That's kind of where I'm coming from.
I guess I can't get past the immateriality because they don't deal with, intervening superseding cause. They deal with negligence in the first place. And that's where I think counsel is confused when she says she's confusing comparative fault with intervening superseding cause.
No, so and your argument's very well taken, and I get it, and it's a good argument, but that's an argument that they're not material. You've kind of returned to that idea. Basically that's your position. I appreciate that.
You're asking me to assume if they are material, I suppose. Or
potentially so. They have to be sort of like summary judgment immaterial, right? I mean, they have to be like, they couldn't be possibly relevant. That's why I started off
have
asking
to
you
be-
about, well, Judge Gates said, well, this can't matter to the jury. She has to be right about that, or else this was error,
I
right?
think it's up to plaintiffs to show that there would have been a difference, a different outcome had this occurred, and they can't show that.
But there
It's-
would be, or that there might be, again, same kind of distinction.
I think that there will be. I think it has to be more than just might. You can't say, oh, there's 400 undisclosed photos, and somewhere in there, maybe there was something that we could have used, we don't know. Because
No, but if they can come forward and say, much like the summary judgment standard, this issue creates a material issue of fact for the jury. These two photos is what they're basically arguing.
Right.
Create a material issue of fact. If that's true, don't they get a new trial?
I
And that's
guess,
the question we're trying to
you know,
unmask.
I suppose they would have to show that two specific photos, not just, oh, there might be something in these 400 photos.
Well, the two that they're talking about, that's what I
Yeah.
think to focus on.
I mean, I guess, you know, if there was some materiality, and I'm having to suspend my logic to go there.
okay. We understand.
Then
It's a
I suppose, I mean, but you would have to find that Judge Gates abused her discretion in the remedy that she did give, and I don't think that she did. But maybe that goes back to because the photos were not material also. So
That's part of the
we're kind of
challenge. I think
changing.
it's-
If we change the case, then sure, in a hypothetical, if you have somebody who doesn't disclose 400 photos and they're material to the outcome, then yeah, I think that could be a problem. I don't think that's this case. Unless there are further questions, I'll just ask you to affirm.
Thank you.
Thank you.
With my apologies for stepping on
No,
your
that
toes.
was, we're asking the same thing, that's right.
Okay.
I'm so eager to ask when you get set up, which photo or photos are the material photos?
The photos, if you go to our expert report, the supplemental expert report where he revised his opinion, he said that he relied on not just, he relied on a handful of the photos that had been identified by the defense as being unique, but he also found additional photos that were helpful for his purposes. And so it's the photos that, if I'm not mistaken, it's the photos that specifically show the measurements of the chairs. Although, and this is a point of clarification, there were other photos that were disclosed previously showing measurements, but they were not as comprehensive as these new photos were. And these new photos gave us the ability to conclusively rule out the smoking chair as the sole piece of furniture that she fell into. Also, I wanted to clarify that the picture of the carport door, you had said that you had asked how many pictures of the carport door were there. There was one picture of the carport door which even defense expert Pathrath had agreed on testimony that was inconclusive. It did not necessarily show that the carport door had a double key deadbolt lock on it or didn't. It was very fuzzy and pixelated.
But wasn't, the carport door was just what opened the
Yes.
door to show, hey, wait,
Right.
here's some photos that haven't been disclosed.
Right.
It's really not, that's the only relevance to it, isn't it, in terms of our appeal?
Right. You know, the critical photos are the measurement photos, and then of course the photos that show that this was an electrical fire, and
20
not
seconds
a.
to wrap up.
What's the most important? The purpose of these disclosures under 26.1 is also to give us an opportunity to properly prepare for trial and to properly assess settlement. That too is what we are deprived of. And I'm out.
Thank you, counsel. We appreciate it.
Thank you so much.
We'll take the matter under advisement. We appreciate the briefing and the quality of argument here today, and we will issue our ruling in due course.